Good afternoon, we say in Amsterdam, and depending on your time, I'm saying good day to you. Welcome to our audience of right now 86 people. We have 263 people registered, so we may get some more that log into us, basically. Welcome to this webinar. We are really happy that you all are here to commemorate together the World Court's advisory opinion of 8 July 1996 on the threat or use of nuclear weapons. We're not happy because this opinion would have ended the existence of nuclear weapons, of course, because that did not happen. But yes, we are happy because it is, whatever one may think about it, it is a milestone ruling. The importance of it is at least that it introduced and that it elevated the rule of international law to the highest level of international legal debate that we know, to the highest level of international litigation that is available to all of us. Since the court delivered its advisory opinion 25 years ago, no debate on nuclear weapons can take place without discussing the legal aspects of nuclear weapons. And that is new. That was not the case before this opinion was delivered. So that's progress. Since then, the finding of the court that, quote, any use of nuclear weapons will generally be a violation of international law, and of quote, is part of the disarmament discussion. Since then, also the court's finding that there exists an obligation to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament in all its aspects under strict and international control, effective international control, expresses the finding of the highest court that this obligation is not an obligation only for states that are a party to the Nuclear Non-Proliferation Treaty, but to all states. That was relevant in 1996, and that is still very relevant today. It's also relevant when we think about follow-up steps to be set to the Treaty on the Prohibition of Nuclear Weapons, which without any doubt is one of the major sorts of progress that the world has made since 25 years ago. Today, we will focus on several highlights, on several topics, and you've seen those in the program. Today also, we are all part of a IALANA experiment. And this is the first time that IALANA is organizing a webinar to a large group of people. And if this format proves to work for us, we will follow up this webinar with webinars that zoom in into specific legal topics, which will, we are sure, enhance the quality of the struggle towards the abolition of nuclear weapons. So we are looking forward to an interesting first today with this webinar, and we hope that you will appreciate this sort of approach from Ayalana as well. I have a few practical remarks to make, which are valid for the rest of the session today. We have in the program, as you've seen, several question and answer sessions after several of the speakers. There is a procedure for that we have decided on before we got started. There is a chat function on your screen, as you all know, but that chat button is only for chat purposes, for submitting comments, sharing information, bilateral chats, what have you. But if you want to ask a question to a speaker, do not use the chat function, but use the question and answer function. And we will have a look at the questions that have come in. If need be, we'll make a selection, and then we'll deal with the questions one by one. So no questions through the chat function, but use the Q&A function. Also, for your information, all of this webinar will be recorded, and you will get information sometime next week about the form and the places where you can find the recordings. So that brings me to our first speaker, and unless I am hearing otherwise from Lucas, I'm afraid that we have not seen Christine Chinkin arriving in this group yet. Lucas, is that correct?
Correct.
So that's a pity, but we haven't heard from her, and we are trying to reach her. So I hope there's no reason for us to worry about this, but I do also hope that she will join us at whatever point in the program that she arrives. And that means that we will begin our session with our second speaker, and that's Paolo Palchetti. And I'm very happy to introduce Paolo to this webinar. Paolo is and has been for quite some time a professor of international law in Italy, since many years at the University of Macerata in Italy. That's, if I'm correct, less than 100 kilometers east of Perugia, or somewhere in that vicinity. He's been there for many years already in that function, and since 2019, he is also a professor of international law in Paris at Sorbonne University, and actually that's where he is spending most of the time, his time right now. Paolo is, as an academic, a typical publisher of articles, books, essays, whatever, what have you. And it's amazing if you're looking up the amount of publications he has in his name. And at least according to all of the titles, they are very interesting and not the easiest topics either. But apart from that, he is also a practitioner of international law and appeared in many cases before the International Court of Justice. He was a member of our legal team in Bosnia's case, Bosnia's genocide case against Serbia. And he also was a member of our Marshall Islands case legal team against the nuclear weapon states. We have asked Paolo to do some educational work today, which will be, what he's going to talk about will be familiar to quite a bit of people already, but also our experience is that it's not familiar to everyone. I'll tell you why. When the court in 1996 delivered its advisory opinion, in the Netherlands, we had at that time a very progressive, very intelligent, very nice Minister of Foreign Affairs. He was a lawyer and a journalist before he became a minister. And he was interviewed about the advisory opinion and asked what the relevance for the Netherlands' position as a NATO member was in his opinion. And he said, oh, well, it's just an advisory. It's just an opinion. So it's interesting, we'll read it, we'll study it, but it's not binding, and therefore it is not something that will change our world. The legal uncorrectness of all of those things that he said at that point is is central to the presentation of Paolo, and I'm happy to give Paolo the floor right now.
Many thanks for your kind words, Phon. Good afternoon to everybody from Paris. I'm very much honored to have been invited to this first conference organized by IALANA. So thank you to the IALANA organizers. And I'm very pleased to see many friends whom I last saw in a sad day in October 2016 when the International Court of Justice rendered its judgment on the admissibility phase in the Marshall Islands case. So we are now celebrating the 25th anniversary of the 1996 ICJ advisory opinion. But let me start with another advisory opinion, the last rendered by the International Court of Justice on February 2019, which concerned the decision made in 1965 by the United Kingdom to separate the Chagos Islands from Mauritius. Why I'm starting from this other case? Well, because I found out a declaration made by a UK minister, which is very close to the kind of reaction Phon was mentioning before from the Dutch foreign minister. Now, the Chagos Islands advisory opinions was a remarkably unanimous decisions, unlike the 1996 advisory opinions and unlike the Marshall Island judgment. The decision was rendered by 13 judges in favor and only one judge against. Despite this, a few weeks after the advisory opinion was rendered, the UK Minister of State for Europe and the Americas, Sir Alan Duncan, issued the following statement. Let me quote it. I quote, "An advisory opinion is advice provided to the United Nations General Assembly at its request. It is not a legally binding judgment. The government has considered the content of the opinion carefully. However, we do not share the court's approach." End of quotation. Now, as a lawyer, we must admit that this statement as such is not wrong. However, this statement is incomplete. It does not say what is the legal effect of an advisory opinion. And if we seek to read along the lines, there are perhaps two messages that this statement seems to convey. First, only binding judgments settling disputes between states are to be complied with. Secondly, advisory opinions are advised to the United Nations and not to states. So states are not the addressee of these decisions. Now, I will address both hidden messages in turn, trying to show how wrong they are. So first, let me start from the distinction between the contentious and the advisory function of the International Court of Justice. And the question is there such a great difference between these two functions of the court? Now, obviously, there is some important differences. First, the jurisdiction of the court to settle dispute is based on the consent of the parties. Without the parties' consent, the court does not have jurisdiction to rule upon a dispute. By contrast, advisory opinions are rendered at the request of the General Assembly or the Security Council, or by other organs of the United Nations if they are authorized by the General Assembly. Now, as you can see, there is no need to rely on state consent in order to for the court to rule upon an advisory opinion. Now, this may certainly disappoint some states. The United Kingdom was extremely disappointed by the fact that the General Assembly asked the court to render an advisory opinion on the Chagos Islands. But apart from this issue, apart from the fact that the contentious jurisdiction of the court is based on consent, is there a real difference on the kind of work the court is asked to do when rendering an advisory opinion and when rendering a judgment? Now, I don't think there is such a great difference. Let me try to explain this. When a state brings a dispute before the court, the primary purpose is certainly to settling in a binding way a dispute with another state. But this is not the only purpose of bringing a case before the ICJ. There is frequently another and no less important purpose: to obtain from the court a decision stating what the law is, what international law is. So let me repeat this. The reasons why states bring cases before the court is also to obtain from the court a decision about the content of the law, a decision that can be used not only vis-à-vis the other party to a case, but more broadly against all other states in any future cases. Let me make an example. Marshall Island case, I'm sorry if I make this example, but it's, given our context, it's the first one that comes to my mind. Now, despite what the court said, there was a dispute between Marshall Islands and the United Kingdom, Pakistan and India. And certainly one of the purposes of Marshall Island application was to settle that dispute with these states. But there was another equally important purpose: to have a decision of a court clearly stating how Article 6 of the Non-Proliferation Treaty is to be interpreted. A decision of a court determining whether the obligations enshrined in Article 6 of the Non-Proliferation Treaty is not merely treaty obligation, but also obligation existing under customary international law. The Marshall Islands were seeking a pronouncement of the court on issues of international law. They were seeking a clarification about the content of the law. And this is what always happens when a state brings a dispute against another state before the International Court of Justice. I can give you dozens of examples. And another case in which I was involved, Germany against Italy, on questions of immunity, Germany asked the court to settle a dispute with Italy about the conduct of Italian courts, but at the same time, Germany was seeking a judgment from the court about the content of the rule of immunity under customary international law. And this element is central in any strategy of a state and any litigation strategy of a state. So let me conclude on this point. And I'm sorry to be repetitive, but I think this is really a central issue. When states bring a dispute to the court, their purpose is not simply to obtain a binding decision vis-à-vis another state. They have a broader interest. The states are aware that court decision serves to clarify what the law is. Court decisions serve also to influence the evolution of the law. And these, irrespective of the fact that the decision has no binding force vis-à-vis third states. Now, the same can be said of the way in which states use the advisory function of the court. When a request for an advisory opinion is made to the court, the purpose is to obtain from the court an authoritative determination of what the law is. And this, irrespective of the fact that the opinion is not formally binding. What counts is the authoritative determination by the principal judicial organ of the United Nations of what is the law applicable in a given area. So in these respects, there is really no difference between a statement made in a context of an advisory opinion and a statement made by the court in a binding judgment. And this may allow me to come and to move to my second point. So Sir Duncan says an advisory opinion is advice provided to the United Nations General Assembly at its request. Does this mean that states have no role at all in the advisory procedure? Now, it is clear that states are the main protagonists. States are the main actors when it comes to the advisory function of the International Court of Justice. And I would say, depending on the content of the request, states are also the primary addressees of the opinion. First, as I said, requests of opinion are adopted by states within the General Assembly or the Security Council of the United Nations. They are the result of long negotiations and compromises between states. But more importantly, states are the main actors in the proceedings, in the advisory proceedings before the court. And this is an essential point that must be taken into account when considering the authority of statements about the law rendered by the court within the context of an advisory proceedings. So in a contentious proceedings, the court establishes what the law is after having heard the views of only two states, the two parties. By contrast, according to Article 66 of the Statute of the International Court of Justice, and I quote, any state or international organization considered by the court as likely to be able to furnish information on the question, unquote, are entitled to participate to the proceedings. All states, not only states, also international organizations. Unfortunately, until now, the court has not recognized to non-governmental organizations the possibility to take part to proceedings. What is the consequence of this provision? The consequence is that when advisory proceedings are pending before the court, dozens of states normally participate to these proceedings. Just to make one example, the 1996 advisory proceedings concerning the legality of the threat or use of nuclear weapons, well, in that case, the written statements were filed by 28 states. And in the course of the oral proceedings, 22 states presented oral statements. A more recent example, the Chagos Islands case. 31 member states of the United Nations plus the African Union filed written statement. Now, it has been said that the determination of international law made by the court in the context of an advisory opinion is more authoritative and deserves greater attention than a statement made within the context of a contentious proceedings. And why? Since the court has had the possibility of hearing the voices of a higher number of states. Now, my views on this is that this is perhaps excessive. Normally, when the court refers to its case law, it mentions opinions and judgments without making any difference and without making any hierarchy between the two. Certainly, it is true that the fact that the court has made a determination of the law after having heard a great variety of different voices enhances the legitimacy of a decision. And this perhaps may explain why certain advisory opinions rendered by the court represented a turning point on specific issues of international law. Let me make few examples. 1949, the reparation case. The court recognizes for the first time the legal personality of an international organization. 1951, the genocide case, the early genocide advisory opinion, sorry. The court clarified the regime applicable to legal reservations, and it changes completely the legal regime applicable to legal reservation. Rapidly, this becomes customary international law. 1971, Namibia case. The court establishes what are the obligations of state concerning the recognition of a situation created by a breach of international law. I could continue. I have many examples, but perhaps it's better to stop it here and just make a rapid conclusion, which could be the following one. The argument that advisory opinion may be disregarded since they are not binding is a very weak argument. It is generally the fig leaf that hides the absence of better arguments able to support the legal position of a state. What counts is not the formal legal force of the opinion. What counts is the authority of a determination of the law made by the International Court of Justice, the principal judicial organ of the United Nations. Thank you for your attention, and I am obviously ready for the Q&A session.
Okay, thank you so much, Paolo. I'm looking at the questions, and on my list, the first question that came in is coming from Derek Harmson, and he says the nuclear weapon states do not follow the advisory opinion of 1996. What can be done today by the International Court of Justice that this situation changes?
Hard question. I mean, Phon, I don't know if you have a reply on this, but there was an attempt to do something. There was an attempt to exploit what the court said in 1996 about the obligation of state to negotiate nuclear disarmament. And the attempt was to bring the issue through the channel of the contentious function of the court. But unfortunately, the court, we are not here for criticizing the court, but the court took a decision on, let me say, on an admissibility issue, not on a substantial issue, and unfortunately prevented a further development of the law, particularly on this delicate and tremendously important issue concerning the negotiation of nuclear disarmament.
Well, of course, we are not particularly here to criticize the court, but it can be part of our job to do so every now and then. If we talk about the Marshall Islands case, I know that people from within the court criticized the court for that judgment. And I heard people say this court changed itself into the Security Council by delivering this judgment in the Marshall Islands case, which is a strong sort of criticism, and it goes very much further than the disappointment that we had when we were confronted with this finding of the court. Basically, I remember that in the Marshall Islands team, this was the point that we all considered that would be not the hurdle that the case would be ending on. And so we were very disappointed, to say the least, at that point in time. And also it's a missed chance, for the missed opportunity for the court to elaborate on its earlier advisory opinion.
But I don't know if I may just add these in order to answer to Derek's question. The importance of the 1996 advisory opinion should not be overestimated. I mean, should not be underestimated. Two cases brought by Marshall Islands against Pakistan and India were based not on the Non-Proliferation Treaty, were based on customary international law. And let's say the strongest argument we had to support the view that exists a customary international rule concerning the obligation to negotiate nuclear disarmament has been provided precisely by the advisory opinion. Without the advisory opinion, I think our position would have been much weaker.
Okay, I'm moving up to the next question from Ariana Smith. Ariana Smith is the recently appointed executive director of LCNP, Lawyers Committee Nuclear Policy in The Hague, in New York. And her question is, what are your, Paolo, what are your speculative thoughts on whether, had the advisory opinion been sought and delivered today rather than 25 years ago, the court might have gone farther, in its opinion, and not left undecided the question of threat or use in self-defense as it did in 1996.
Now, first, congratulations to Arianna for the new position, and then it is always hard to make this kind of assessment. It depends entirely, I would say, on the composition of the court. That is my personal view, but again, it's really something hard. Sometimes the court surprises. Sometimes the court takes position one would not have expected from the court. But the impression I have is that the court probably also feeling the atmosphere surrounding the activity of the United Nations. I mean, the multilateralism, we all know, is in crisis right now. The court has a much more prudent position nowadays than it had in the 90s, early 20s, 2000. That is my personal feeling. I mean, I might be wrong, and again, sometimes the court surprises. But the impression I have is that the court nowadays is more prudent, which means I would not have expected much more should the request of advisory opinion be presented to the court in this moment. I don't know what is your feeling about this one.
I see that there is a question which is a sort of follow-up question to this one, coming from Robin Collins, and he or she says, what are the risks of going back to the court to resolve some ambiguities as compared to advantages, which is a familiar question that clients ask to lawyers, and it's a very prudent question to ask because sometimes it can just work very badly to press the court on certain issues. But what's your view, Paolo, on going back to the court and asking a clarification through an advisory opinion of the last part of its advisory opinion, the part that was central to the Marshall Islands case? Did the court actually mean to say that the disarmament obligation of Article 6 of the NPT should be handled as an obligation of customary international law, so an obligation for all states? What would your assessment be if asked to?
Now, again, all these speculative issues are hard to be responded, but I'm generally rather activist when it comes, should we go to the court? I would say, why not? I think that the court, on the question of negotiation, I mean, we are not, should the question be put again before the court? Should state negotiate? I think this is not such a revolutionary request to determine the existence of element of practice as attesting the existence of an obligation to negotiate. Negotiation is the basis of relations between states. So depending on the question one is putting to the court, I think the court could find, it is always very careful in finding a solution which has sound legal basis in practice, but which is also reasonable in terms of, let's say, conflicting interest. So I would say that a clarification on this issue, well, this could be an interesting subject to be submitted to the court. And the court here could find some elements for supporting the, I would say could easily find some element in order to support the existence of a customary obligation. Then, there is always a problem of formulating advisory requests. The problem of how to formulate a request for an advisory opinion is a very delicate one, because the court sometimes, let's say, is able to interpret the request in a way that allows it to avoid the most delicate aspect of the issue. So formulation would be really central to the success also of a request for an advisory opinion.
Thank you for that. There is a question of Sylvia Boyce, Sylvia Bois. I don't know what the right pronunciation would be. Is there an opinion that the ICJ ruling led the way to the TPNW, to the BAN Treaty? I don't know whether you have views on that, but otherwise I would like to refer the question to the second session in which Amela Skillion is going to talk about the TPNW, and then we'll ask her to take care of this question as well, Sylvia. Then there are two submissions from Kalani James Evans, but I don't see the question in. It's more like information or comments. So I think we'll try and move on. I see that there are more questions there, but I'm not getting them on my screen. I need help. Lucas?
There should be a button to click further down to the questions, but maybe it's also time to stop the questionnaire because it already went on for 10 minutes. I don't want to deal with the time.
Yes, I understand. Let me see. Oh, there is a question which is more like a chat. So, okay. Well, then, Paolo, thank you so much for your talk and for your thoughtful insight. And I'm very happy that you appeared here, and I hope that we will be able to have the advantage of your input in future versions of the webinar. Thank you so much. And then we will move on to Peter Weiss. And I'll introduce Peter Weiss first to you, although this is someone who doesn't need any introduction to most of us, but maybe not to all of us. The late Sean McBride, he was a lawyer from Ireland. He was a Nobel Peace Prize winner, among many, many, many other things. Sean McBride assembled a first-time ever gathering of lawyers on the topic nuclear weapons and international law in Geneva in 1984. And among the 35 attendants of that meeting, there was one lawyer that struck me most. He was very eloquent. He was extremely clear in his legal reasoning, and he was at the same time extremely committed to the goal of a world without nuclear weapons. He was and became an example also for me of the true activist lawyer. He turned out to be Peter Weiss, a corporate lawyer in New York, a human rights activist, and a co-founder of the LCNP, a co-founder and the soul of the LCNP, I must say. And he became also the one of the co-founders and the soul and the heart of IALANA ever since its founding in 1988. Peter was instrumental for IALANA's legal input for what became the World Court Project, and Alan will talk about that later. Peter was, at the time of the advisory opinion, a member of the Malaysian legal team, and he presented Malaysia's position, which happened to be also IALANA's position, in the Great Hall of Justice during the oral proceedings of the advisory opinion case. Until very recently, Peter was president of IALANA. It's a long time ago that Peter turned 90 years, and we have lost count ever since. And I would like to say, give him a standing ovation, but I don't know whether that will really work in this setting. Peter, you have the floor for general observations. Please go ahead.
Well, I also want to welcome all the 162 people who are presumably on this call. So good morning, good afternoon, good being with you, whatever. My first point today, actually my very first point, should be to tell Paolo that he will not have any problem with my agreeing his brilliant analysis of what an advisory opinion really means. And then I want to say something quickly that is a little bit beyond the scope of my presentation, but I wanted to get it into the record. And I want to give you an idea of how active IALANA has been by giving you the names of the countries where it has held meetings in the last 25 years. So here goes with that. Or maybe I will ask Cora to read that part, my wife, who has been very involved with nuclear weapons for a long time.
Meetings were held over the last 25 years in Stockholm, Berlin, Moscow, Stettin, Poland, San Jose, Costa Rica, Paris, Brussels, Geneva, Montreal, Hiroshima, Vienna, Lausanne, and New York City.
Well, that's pretty impressive, isn't it? And
Here.
yes, thank you. You will have noted that this list of countries is Eurocentric, and I hope that that will be corrected in the next 25 years, because we should be active throughout the world and not just in Europe. Now, perhaps the most striking thing about the weapons, about the effect of the ICJ opinion has had on the anti-nuclear movement was to energize that movement. Non-lawyers started lecturing on international law. Lawyers started thinking about the next case to bring. And the judges of the ICJ, I can only say, were regarded as having taken us to the Holy Grail. But this infatuation with the law did not last. People asked why there are still nuclear weapons when we have such a wonderful decision from the ICJ. Nevertheless, there has always been a hardcore
Yeah, Lucas.
Is he still on? Hello? Hello?
Am I? Can you hear?
Yes, we still hear you.
What?
We still hear you, Peter.
Oh, okay.
So you're the hardcore, always been a hardcore.
Nevertheless, there has always been a hardcore of believers in the role of law as the mover of social progress. See, for instance, Jackie Cabasso's excellent article, which has just been published under the title of Nuclear Weapons Have Always Been Illegal.
But for every believer.
But still, for every believer in this role of the law, there are many more doubters. And the challenge to us at Iolana is to reverse that proportion. How can that be done? Let me make a few suggestions. One, whenever something about nuclear weapons is said or written, the word abolition should be at the very beginning of that, and not as a kind of throwaway, by the way, reaction at the very end. I have seen too many excellent papers about risk reduction that go on that subject. And then at the very end, there's something that comes in as saying, oh, and by the way, we are really for abolition. That has to go. Two, the mostly Catholic protesters who have been willing to serve time in jail to support their anti-nuclear protests certainly deserve our admiration. But not everyone has to share their heroism. What would you think, for instance, if a dozen or several dozen people staged a kind of ballet in which people would be using, in which people would be equipped with replicas of the nuclear football. You all know what that is. It's the thing which contains the code that a president has to use to launch nuclear weapons. So let's try, okay. 3, beware of compartmentalism. The manufacture and storage of nuclear weapons creates many more issues, including the environment and racism. We need to work with organizations concerned with these issues. 4, encourage the formation of extracurricular school activities dealing with subjects such as diplomacy, peacemaking, and nuclear weapons. And finally, let the students of today become Ayala's leaders of tomorrow. Thank you.
Well, thank you so much, Peter, for this contribution. And I know there are quite a bit of students in the audience, so I trust that they have heard your last paragraph, which I think is supported by all of Ayalana, at least. So thank you very much for your presentation. It's great to see you again, and I hope you have time and energy to hang on to the screen for the rest of the seminar. Then, in the meantime, Christine Chinkin has arrived. Christine, are you able to appear on the screen? Yes, there are you. There you are.
Yes, I'm here.
Yes,
Yeah, and I'm
yes.
on the screen.
Yes. I took the liberty of moving you to this spot in the program, and Ellen Ware has agreed to be rescheduled into the second session. But we're running a little bit shorter in time because Paolo was so friendly to fill up a part of your time spot since you weren't there. But we're happy you're here now, and we'll have to improvise a little bit, but I'm sure that is not the first time for either one of us to do so. So let me introduce Christine Chinkin to you. Christine Chinkin, since decades, have been professor of international law at LSE in London. She's also the founding director of the Center for Women, Peace and Security at LSE, which is a very well-known think tank for issues relating to women, peace and security. She was also a member of our legal team representing the Marshall Islands before the International Court of Justice in the cases against the nuclear weapon states. Recently, and that's the most important thing for now, I think, Christine published a joint opinion on the new UK's integrated review of its nuclear policy. And this new policy includes, among other things, a 40% increase of the UK's nuclear arsenal. And no surprise that Christine's joint opinion, she produced it with a colleague of hers, is extremely critical on this new policy. So Christine, I lost you on my screen, but I hope you're still close to yours, because I want to give you the floor, please.
Okay, thank you, Phon. I'm not quite sure what happened there. The internet vanished on me. So first of all, I have to say thank you very much for the invitation to join you and the 25th anniversary of the advisory opinion on nuclear weapons, and also to apologize for the confusion over the time. So what I'm going to do, and I'll try and keep it to time, is to discuss the continuing validity of the advisory opinion in light of the UK nuclear policy as it was recently announced in its integrated review of security, defence, development and foreign policy issued in March of this year. So I'm basically going to do this through two questions. How compatible is the current UK nuclear policy with the advisory opinion? And does the advisory opinion 25 years later still stand up, or have changes in international law, in the geopolitical situation, in weapons, communications and other technologies since 1996 undermine its contemporary relevance? To put it more concisely, should we still care about the advisory opinion? And my conclusions are simple. To the first question, the UK nuclear policy is not compatible with it. And to the second, yes, we should still care about the advisory opinion. 25 years later, it still has important messages for states and other actors within the international arena. But first, just a few comments about the integrated review, the UK policy. In it, the UK announced that it would, quote, move to an overall nuclear weapon stockpile of no more than 260 warheads and would modernize its existing nuclear system. So this announcement denotes an increase in the UK's overall nuclear weapon stockpile from 180 to 260 warheads, a rise of more than 40%. Now this was startling. In 2010, the then coalition government had stated that it would, quote, reduce the number of warheads from 48 to 40, in line with our commitment vigorously to pursue multilateral global disarmament, and to reduce our overall nuclear warhead stockpile ceiling from not more than 225 to not more than 180 by the mid-2020s. This position was reiterated in 2019 in the draft national report prepared for the 2020 review conference of the Nuclear Non-Proliferation Treaty, the NPT. So this announced increase is a complete reversal in policy that represents, for the first time since the end of the Cold War, that the UK has sought to increase its stockpile. It's a decision that, in the words of one commentator, has not been discussed in public and one that has received too little attention. But this is not the totality of the UK's expressed nuclear policy. The integrated review also set out when nuclear weapons might be used. It begins with the statement that use of nuclear weapons would only be considered, quote, in extreme circumstances of self-defense, including defense of our NATO allies. It continued that the UK will not use or threaten to use nuclear weapons against any non-nuclear weapons state party to the NPT, but that this assurance does not apply to any state in material breach of those non-proliferation obligations. Moreover, it reserved the right to review this assurance if the future threat of weapons of mass destruction makes it necessary. I think a couple of words about context are important. So first, the integrated review was adopted at what was called an important moment for the UK, Brexit, with the departure from the European Union in January, provided what was called a unique opportunity to reconsider many aspects of our domestic and foreign policy, in effect to forge the UK's own path as so-called global Britain. Second, at the heart of the review lies an increased commitment to security and resilience, so that, again to quote, the British people are protected against threats. Third, despite the commitment by the government to be a force for good and an assertion that the UK will remain a world leader in international development, the UK cut the overseas aid budget from 0.7% of GDP to 0.5%, reportedly amounting to some £4 billion. Now, returning to the advisory opinion, of course, it set out the parameters for the determination of the legality for the threat or use of nuclear weapons, answering the question put to it by the General Assembly through looking at multiple specialist regimes of international law. The law relating to the recourse of force, IHL, international humanitarian law, human rights law, environmental law, and the nuclear NPT, Nuclear Non-Proliferation Treaty, Article 6. And alongside the legal parameters, the court asserted the imperative to take account of the unique characteristics of nuclear weapons, in particular their destructive capacity, their capacity to cause untold human suffering and damage to generations to come. Now, I want to make just two preliminary points about the advisory opinion. First, international law is not static, and the specialist regimes the court focused on have not stood still for the past 25 years. There have been new treaties, interpretation of those treaties through jurisprudence, through review conferences, through authoritative expert opinions, all of which ensure the character of international law as a living dynamic system, as well as the emergence of new norms of customary international law. So in asking the same question today about the legality of nuclear weapons, this dynamic legal evolution must be taken into account, although the starting points remain the same, and the court's guidance as to the applicability of those starting points also remains relevant. Second, there's an important distinction between the advisory opinion and its application to the UK's nuclear policy. The court's opinion was abstract. It was not directed at any particular state's behaviour and was therefore crafted for all states and for different situations, including the hypothetical instance of an extreme circumstance of self-defense, in which the very survival of a state would be at stake. The court has, of course, been faced with the opportunity to rule on the legality of specific instances of nuclear policy. The 1974 cases brought by Australia and New Zealand against French nuclear testing, and the more recent case brought by the Marshall Islands against the nuclear weapon states for their failure to comply with Article 6 of the NPT. To quote Judge Trindade in that Marshall Islands case, in both those instances, the court pursued a rather evasive posture, avoiding to pronounce clearly on the substance of a matter pertaining to the very survival of humankind, preferring instead to fall back on or hide behind questions of jurisdiction and admissibility. Now, I can't, of course, in the time I've got left, go through the many reasons why I consider the UK's nuclear policy to violate international law. So what I'll do instead is make comments on three areas very briefly: recourse to the use of force, human rights, and Article 6 of the NPT. So first, the use of force. In the advisory opinion, the court accepted that any threat or use of force of nuclear weapons, contrary to Article 2.4 of the Charter, would be illegal. But it also, of course, gave great weight to states' inherent right of self-defense under Article 51. The UK echoed the wording of the court's conclusion in setting out its nuclear policy, that nuclear weapons would only be considered in extreme circumstances of self-defense. Presumably, the UK is assuming that this gives legitimacy to its current position. But the UK does envisage a potential use of force. Its assurance that it will not use or threaten to use nuclear weapons against any non-nuclear weapon state party to the NPT does not apply to any state in material breach of those non-proliferation obligations, while it also reserved the right to review this assurance if the future threat of weapons of mass destruction makes it necessary. The first part of this statement confuses legitimate countermeasures in response to a prior material breach of a treaty with the right of self-defense, which under Article 51 only arises when an armed attack occurs, therefore making the second part of the statement also problematic. But more specifically, under the law of state responsibility, material breach of a treaty by a state party may permit another state to take countermeasures, but such measures expressly exclude the right to threaten or to use force. Secondly, on this, the ICJ has not advanced an expansive reading of self-defense. It's repeatedly asserted that force used in self-defense under both treaty and customary international law is subject to the state concerned having been the victim of an armed attack. The right of anticipatory self-defense has, of course, long been contested, but in the context of the 2003 invasion of Iraq, the so-called Bush doctrine pushed this further to attempt to encompass preemptive self-defense, use of force to preempt some potential future threat. But this concept of preemptive self-defense has not been accepted by state practice, and some undefined future threat does not give rise to the lawful use of force in self-defense. At a minimum, the anticipated attack must be imminent. And further, as the court reiterated, under customary international law, a legal exercise of self-defense is subject to the conditions of necessity and proportionality. In another reflection of the language of the advisory opinion, the UK allows that review of its assurance not to use nuclear weapons would only arise if a future threat made it necessary. But the UK is apparently seeing this as a subjective matter. A message from the advisory opinion is that assessment of legality must be objective against the legal criteria outlined, a message reasserted in the oil platforms case. And the ICJ also reminded states that Article 51 specifically requires that measures taken by states in the exercise of the right to self-defense be immediately reported to the Security Council, another indicator of the requirement of objective evaluation of the criteria. The court unanimously opined that the threat or use of nuclear weapons should also be compatible with the requirements of international law applicable in armed conflict, the principles and rules of IHL that apply even to a legitimate use of force in self-defense, notably the principles of distinction and proportionality. Even back in 1996, it questioned whether the use of nuclear weapons could be proportionate, given their devastating effects in terms of scale, scope, duration, and intensity. Again, in the words of Judge Shriddade in the Marshall Islands case, he said, nuclear weapons simply ignore the IHL principles of distinction and proportionality and upholding the prohibition of infliction of unnecessary suffering. The judge continued that the advisory opinion recognized both that nuclear weapons cause indiscriminate and durable suffering, have enormous destructive effect, and that these principles of IHL are of an intransgressible character. But the court did not allow these considerations to discard the use of such weapons in the ultimate of self-defense. He concluded that states are bound to respect and ensure respect for IHL, quote, in any circumstances, their fundamental principles belonging to the domain of use cogents. States must also, of course, respect and ensure human rights law, including the right to life under the International Covenant on Civil and Political Rights, Article 6. The advisory opinion observed that the ICCPR guarantees do not cease in times of war, but then dealt somewhat perfunctorily with the right to life. Now here law has again progressed. 2 years ago, the Human Rights Committee adopted a new general comment on the right to life. This provides a comprehensive legal condemnation of the threat, use, production, and possession of nuclear weapons, and spells out that these are incompatible, strong word, with the respect for the right to life, and may amount to a crime under international law. States must therefore take all measures to stop the proliferation of such weapons and destroy existing stockpiles. The UK is a party to the ICCPR, but in comments to a draft of the general comment, it stated that it did not support this part of the comment. It reiterated the court's opinion that the use or threat of use of nuclear weapons is subject to the law of armed conflict, not human rights law, again, resting firmly in the advisory opinion. I don't think, however, that the words of the Human Rights Committee can be so easily dismissed. The ICJ has accepted that the human rights treaty bodies bestow an authoritative interpretation of the particular human rights treaty they are addressing. The court described the Human Rights Committee as, quote, an independent body established specifically to supervise the application of that treaty, and its views should be given great weight. The Human Rights Committee also asserted that the use of nuclear weapons might amount to an international crime. International criminal law does not figure strongly in the advisory opinion, although the court did observe that the humanitarian rules in the 1907 Hague Regulations were regarded as declaratory of the laws and customs of war. ICL, as international criminal law, has of course progressed significantly since 1996, including through the adoption of the Rome Statute. The Rome Statute does not specifically address nuclear weapons, but many of its provisions allow for the inclusion of their use to be constituted under crimes against humanity or the laws and customs of war when the other criteria are present. The UK, of course, is a party to the Rome Statute. Despite the UK government's professed commitment to universal human rights, its intention to increase its nuclear warheads and modernise its nuclear system are not, I would maintain, in conformity with the Human Rights Committee understanding that practices contrary to IHL are also inconsistent with the right to life under human rights law. This requires that weapon systems not be developed. This is also consistent with the views of regional human rights institutions that have taken into account the relevant principles and norms of both human rights law and international humanitarian law, and importantly, drawn attention to their underlying principles, including the principle of humanity. The Human Rights Committee General Comment additionally notes that states parties to the ICCPR must also respect their international obligations to pursue in good faith negotiations in order to achieve the aim of nuclear disarmament under strict and effective international control. This language recalls that of Article 6 of the NPT. The NPT negotiation history makes it clear that Article 6 is a core component of that treaty. It reflects a strategic bargain between the many states that renounced acquisition of nuclear arms and those states that then possessed them. The treaty preamble makes clear that among its objects and purposes is the obligation to undertake effective measures in the direction of nuclear disarmament. The court, in the advisory opinion, also appreciated the full importance of Article 6 of the NPT to put an end to the continuing disagreement about the legal status of nuclear weapons through the long-promised complete nuclear disarmament as the most appropriate means of achieving that result. An obligation to negotiate in good faith nuclear disarmament, an obligation it said was of result, not merely of conduct. Good faith is a basic principle governing the creation and performance of legal obligations. In the words of the court back in 1974 in the Australia-New Zealand nuclear weapons cases, the court said the trust and confidence that are inherent in international cooperation in particular in an age when this cooperation in many fields is becoming increasingly essential. The UK's unilateral announcement of its intent to increase its stockpile of nuclear weapons indicates a position contrary to a good faith intention to negotiate. The assertion of commitments that are then disregarded apparently at will is not in accordance with good faith behaviour, and I would assert it constitutes a material breach of NPT Article 6 that occurs legal responsibility under both the law of state responsibility and treaty law. And I would also note that in 2017, following the Marshall Islands judgment, the UK made a further reservation to its declaration, accepting the compulsory jurisdiction of the ICJ, stating that the UK does not accept the jurisdiction of the court, quote, in any claim or dispute that arises from or is connected with or related to nuclear disarmament and or nuclear weapons, unless all of the other nuclear weapon states parties to the NPT have also consented to the jurisdiction of the court and are party to the proceedings in question. This reservation seeks to ensure that the UK's obligations under the NPT Article 6, reiterated strongly in the advisory opinion, cannot ever be objectively adjudicated upon by the court. The UK is, of course, entitled to make reservations to its acceptance of the jurisdiction of the ICJ, but this does not sit well with an obligation to pursue in good faith negotiations towards effective disarmament. To conclude, I think the UK Integrated Review presents a vision of the UK in its post-Brexit world. By its use of language, it apparently considers that the advisory opinion protects its nuclear policy from condemnation as incompatible with it, while of course discounting the obligation to negotiate disarmament. But in this regard, the UK is only looking back, not forward, to take account of legal and social evolution in the 25 years since. But more fundamentally, I do not think that its vision is that of the ICJ. The ICJ is clear that the international rule of law must be upheld, that promises must be kept. It envisages a world where states have a positive duty to pursue in good faith and bring to a conclusion negotiations leading to nuclear disarmament. The ICJ's vision is of a world where treaty commitments do matter, where customary international law unfolds, where cooperation and negotiation are paramount, rather than unilateral assertions of policy at odds with the state's treaty commitments. And perhaps after 25 years, a world where an aggressive militaristic assertion of national security might just give way to a people-centered, planetary-centered vision of peace and security.
Thank you. Thank you so much, Christine, for your presentation. And I'm sorry that this had to be dealt with in a shorter time than foreseen, but such is life. And I noted that you included, obviously, quite some references to the human rights general comment produced by the Human Rights Committee. And if people would have remarks or questions on that issue, I think that Daniel Whitaker's talk in the afternoon, the second part of the program, will provide for an opportunity to pose more questions if there are on the human rights aspects. So that I hope, Christine, that you will still be around by that time. So you may want to participate in.
I'm not sure. I'll see, I'll see, yeah.
Okay. Okay, then we'll have to hurry on before we get to the break. We'll have to hurry on with the with another important part of the program. And that's the message that we're going to receive from Japan. Takeya Sasaki is one of the co-presidents of Ayalana, and he represents one of the strongest affiliates within Ayalana. It's called Yalana. And this affiliate has been in existence for decades already, and I think it's one of the most active chapters from Ayalana, and that's for obvious reasons, I would say. Takeya Sasaki was not able to participate in sort of in his own presence, so he has sent us a video message which we'll show you right now, and then immediately after that showing of that video, we'll move on to the break. We have a 15-minute break, and be sure to be back within 14 minutes of the break, so we will be able to start the second session timely. So please now we'll give the floor to Takeya Sasaki from Japan.
Hello everyone, I am Takeya Sasaki, a lawyer in Hiroshima and one of the Iadana co-presidents. 76 years ago, on August 6, 1945, a single atomic bomb dropped on the city of 350,000 residents, killed 140,000 people by the end of the year. I was only 5 years old at that time, 31.5 kilometers away from the hypocenter. A flash of the atomic bomb lit over me. I heard a tremendous sound of explosion and I saw the mushroom cloud. Now I'm talking to you from my office, located 1.4 kilometers away from the hypocenter. Do you know the Shimoda case? It's the judgment handed down by Tokyo District Court in 1963. The first judgment that concluded that the atomic bombings were illegal under the international law. Mr. Shimoda was also 1.4 kilometers away from the hypocenter. His wife and two-year-old son survived with him. The bomb left killed on his right arms from the bad bang. Mr. Shimoda also suffered from liver and kidney diseases and lived through the post-war days, suffering from the illness which was caused by atomic bomb. Mercilessly, the atomic bomb killed his 5 children aged 16, 12, 10, 7, and 4. It breaks my heart to imagine the feelings of the couple. The Shimoda case judgment said the act of dropping such a cruel bomb is contrary to the fundamental principle of laws of war, which prohibits the causing of unnecessary suffering. In 1992, Iadana launched the World Court project in order to judge nuclear weapons, cruel weapons of devil in the ICJ. 2 years after, we established the Japanese Association of Lawyers Against Nuclear Arms. We gave lectures several times to raise awareness of citizens. In May 1995, we went to the ICJ to tell the reality of atomic bombings. We donated photographs, videos, testimonies of Hibakusha and papers that illustrated the tragedy of Hiroshima and Nagasaki to 14 ICJ judges and the library. We requested that they should beat Hiroshima and Nagasaki to listen to voices of Hibakusha. We urged the Japanese government to apply for mayors of Hiroshima and Nagasaki and Hibakusha as council and submit photos, the atomic bombings as evidence, but government refused it. Submission of Republic of Nauru to the ICJ stated that threat or use of nuclear weapons would be legal. Then we asked Nauru to apply for testimonies of Hiroshima and Nagasaki mayor. And then they started to do so. In September the same day, same year, France forced nuclear testing in Mururoa Atoll, but submission by the government of Australia and New Zealand were negative. We required both governments to make them positive, and they changed their submission. These moves made the government of Japan, the atomic bombed country, afraid of losing its face. After all, they decided to have both mayors as council. In November, both mayors demonstrated the tragedy of Hiroshima and Nagasaki at the Great Hall of Justice. The Treaty on the Prohibition of Nuclear Weapons, or TPNW, came into effect this year, which marks 25 years since the adversary opinion declared that threat or use of nuclear weapons would be illegal. This is a great progress toward the abolition of such weapons. We will urge the Japanese government, who turned their back on this treaty, to ratify it at an early day. This is decision of adversary opinion. Paragraph F of dispositive of adversary opinion states that there exists an obligation to pursue in good faith and bring to a conclusion negotiation leading to nuclear disarmament in all its aspects under the strict and effective international control. In order to bring to a conclusion, we will struggle along with you toward abolition of nuclear weapons. I look forward to the result of today's gathering. Thank you very much for watching.